Hello there. How are you today? My name is Bobby Harges, and I will be discussing theft today. That's the topic of our lecture. We will discuss common law theft, which was known as larceny, as well as modern day theft. You should have available for your use a set of PowerPoint slides that I uploaded to the internet, and you can use those to follow along with this lecture. Larceny was the only felony theft offense at the early common law. Larceny was a crime against possession. In other words, for there to be a larceny, the property must have been taken from the victim's possession. Larceny was a crime against possession. It was designed to prevent breaches of the peace, not aimed at protecting property from wrongful aspiration. In other words, from a wrongful taking. Here I have a slide with the elements of common law larceny. It was a trespass, taking, and carrying away of the valuable personal property of another with the intent to permanently deprive. I will go over each of these elements so that you can get a pretty good understanding of the elements of the crime. Trespassory taking. For there to be a trespassory taking, there had to be a breach of another's peaceable possession. The theft had to be from the person or possession of another. That was critical for the crime of larceny. Let's look at an example here. A hires D to take goods from New Orleans to Baton Rouge. D decides to take the goods to his home in Gonzales. In other words, to keep them and not transport them as agreed. Is this larceny? What do you think? Yes or no? Well, let's take a look. No, that offense would not be larceny under the common law definition. Why? Because there was no trespassory taking. Because the goods were lawfully given to D. D had possession. D had lawful possession. Thus, there was no trespassory taking. Therefore, he did not commit larceny. Again, remember, larceny required a breach of another's peaceable possession. There was no breach of the peace with the transfer of goods from A to D. Therefore, the fact that D took them later or decided to keep possession of them later instead of transporting them as agreed, that was not a larceny. Thus, in this case, D did not commit a larceny. Larceny is a crime against possession, and D was given possession. Another example, a bank teller takes $1,000 from a drawer that she uses daily. That bank teller is given custody and possession of those funds, and that person decides to misappropriate. Is that larceny based on the common law definition? What do you think? Yes or no? The answer is no, because the teller was given lawful possession. Therefore, there was no trespass in the taking. Therefore, there was no larceny. You may know this crime as embezzlement, but embezzlement was not common law larceny. With larceny, as with any crime, even in the common law and today, if all the elements are not met, the person has to be acquitted of that crime. So because so many people were getting really away with criminal conduct, The law had to change to fit the society and to fit the circumstances of society. So other crimes were created judicially or statutorily to cover these loopholes. Here's another example. D takes cabbages from A's garden at night without permission. Is that larceny? The person goes to the garden at night, severs the cabbages, and takes them. What do you think? No. Why not? Why was that act of going to a garden at night not larceny? Because at common law, larceny was limited to the misappropriation of goods and chattels, that is, personal property. And cabbages that were still growing from the ground were not considered personal property. They were immovable, part of the land. Trees, crops, minerals, and fixtures, which become personal property after severance from the realty, the common law view was that it was not larceny to sever the property and carry it away in one continuous act. And make a note, the key here is one continuous act. What if D severed the cabbages on Monday night and carried them away on Tuesday night? Is that larceny based on the common law definition? The answer is, what do you think? Yes or no? Yes, here, because the severance and the aspiratation are two separate acts. The cabbages, once severed on night number 1, became personal property, and when he came back on night 2 to pick them up, he committed the larceny. The property had to be of another. You could not commit theft or larceny of your own property. Therefore, wild animals were not considered personal property. Abandoned property, because you can't identify who owns the abandoned property. It's not of another. What about this hypothetical? The owner takes his car from a mechanic without paying the $500 service fee. Would that be theft in the common law? Are you taking property? If you look strictly at the definition now, you're not taking valuable personal property. So that might not fit the definition. Now, you know, today, if you were to take your car without paying the service fee, that would be covered under our definition of theft. So again, larceny, trespassory taking, and carrying away of the personal property of another with the intent to permanently deprive. Gradually, the courts began to expand the reach of the offense of larceny, initially by subtle alterations in the common law concept of possession. Thus, for instance, it became a general rule that goods entrusted to an employee were not deemed to be in his possession, but were only considered to be in his custody, so long as he remained on the employer's premises. This was a way to change the law to make sure some of the conduct that was not prescribed initially became illegal. Courts began to create fictions in order to meet the elements of common law larceny. Again, as we mentioned earlier, people charged with larceny were acquitted, or the convictions were reversed on appeal. New crimes were created. What are some of those new crimes? Larceny by trick, created by the courts. Embezzlement is a statutory crime. False pretenses, also a statutory crime. Well, now let's fast forward to the 21st century and look at the definition of theft based on the Louisiana Criminal Code. Under the Louisiana Criminal Code, theft is a misappropriation or taking of anything of value of another, and the mens rea is with the intent to permanently deprive the person of that property. Now let us look at the definitions here. What does the phrase thing of value mean? For that, we have to go to the Criminal Code, Revised Statute 1402, subsection 2. Anything of value must be given the broadest possible construction, including any conceivable thing of the slightest value, movable or immovable, corporeal or incorporeal, public or private, and including transportation, telephone, and telegraph services, or any other service available for hire. It must be construed in the broad popular sense of the phrase, not necessarily as synonymous with the traditional legal term property. In all cases involving shoplifting, the term value is the actual retail price of the property at the time of the offense. What about those crimes that were considered larceny, larceny by trick, embezzlement, false pretenses? Those are all covered by our general theft crime in Louisiana, which is 1467. So we're going to make it easy for you. You don't have to know 4 or 5 different theft crimes. You simply have to know theft and the elements. Let's look at State v. McIntyre. The charge was attempted theft of entertainment services. This is something that many college students have done and perhaps thought nothing about it. They exchange ID cards, and if you can't go, you've paid for the price of the game through your service fees, you give your card to someone else. Well, in this particular case, we have one Amos W. McIntyre, who was charged on the 9th day of October in the year 1971, in that he unlawfully attempted to commit a theft of entertainment services valued at $7, the property of LSU Athletic Department, by fraud and misrepresentation. The facts show that he basically tried to enter a LSU football game. He wanted to use the card of another. He was not allowed admission to the game. The court said that this is not theft. Now, does this mean that an LSU football game is not a thing of value, that is worthless? No, clearly that is not what the court is saying, because based on LSU performance of late, the value of that game is quite expensive, as all of you know. But I think the court made a policy decision to say that this is a matter of internal discipline. We don't want things that is just fun and game for the things that are fun and game for students to be something that's subject to criminality. So the court said that notwithstanding the broad definition, this is not theft, and this is not what the criminal code intended. I think this is a very good decision, because this is not, in my opinion, what the criminal code was designed to do. Now, could the court have held the other way? Of course it could have, but it decided not to in this instance. Let's look at modern day embezzlement. The next case is State v. Coleman, where basically a Nathan Coleman was charged by bill of information with theft of U.S. property valued at more than $500. He worked for a Chick-fil-A restaurant in New Orleans Center. He was one of the managers. Basically, he had the people to take orders from customers and not ring them up, and basically put the money aside, and he took the money for his own use. This is what we would call embezzlement. Now, as you recall, we don't have a crime called embezzlement. This is simply theft. The manager was suspicious, figured out a way to catch him, and this person was convicted, and the case on appeal was affirmed. This case is here to present to you, as the notes after the case point out, that this is an example of embezzlement, where one entrusted with a thing of value misappropriates or takes that thing of value. So the point from this case is that the Louisiana theft statute covers embezzlement. This is a misappropriation. Now remember, this would not be common law larceny because the manager, the person charged, Coleman, had lawful custody of the money. So let us look at anything of value, the definition in the year 2012. Unauthorized viewing of an LSU football game or the attempted unauthorized viewing, not subject to the theft statute. What about a person going into a grocery store, picking up a can of Static Guard, and the pants have wrinkles, and that person sprays the Static Guard and decides not to purchase and puts the Static Guard down? Now, Static Guard is a fabric conditioner and anti-static electricity product sold in aerosol cans. In this case, a security guard saw the individual spray the Static Guard. And once she tried to leave, he said, you either pay for the Static Guard or we're going to arrest you for theft. And she was arrested and she sued for, I think, false arrest. And the court said basically that was a theft because she took something of value from the store. What about this case? We had in State v. Marcello a homeless man who went to a public service utility. He climbed to the second story of a window, saw the window open, went in to take a shower or to clean up before he went to interview. So he used soap and a paper towel without consent. And he was charged with burglary or attempted burglary. And so the underlying crime to make it a burglary was the intent to enter to commit a theft. But the court said that that is not a theft. Now think about it. The use of Static Guard is a theft, but taking soap and water is not. What is the meaningful distinction between that? Two different courts, one in the Louisiana Supreme Court and one at the Fourth Circuit, one 1986 and one is 1980. What about a person who decides to take the automobile of another for a joyride and to bring that car back? The car is not damaged. Is that theft? Well, we have another name for that crime. It's called unauthorized use of a movable. It is in your statutory supplement under 1468. Unauthorized use of a movable is the intentional taking or use of a movable which belongs to another, either without the other's consent or by means of fraudulent conduct, practices, or representations, but without any intention to deprive the other of the movable permanently. The fact that the movable so taken or used may be classified as an immovable according to the law pertaining to civil matters is immaterial. So that would not be a theft because there's no intent to deprive permanently. But what about taking a rental car that is for hire, using that car for your purposes, and yet you're going to bring the car back? You have no intent to deprive permanently. I think in that instance, you could be charged with theft of the value of the rental car because that car is for hire. Whereas the theft of the automobile, that's a different factual scenario. We talked about this earlier. What if a person drove off without paying a mechanic after the mechanic rotated the tires? The cost of the rotation is $10. That would be covered under our modern day theft statute. Theft of services or the value of the service to rotate the tires. The district attorney could easily charge that and get a conviction. Shoplifting, as you know, shoplifting is a crime. It is theft in Louisiana. The case we are going to discuss today is State v. Ellis. In State v. Ellis, we have a security officer behind an observation window saw Miss Ellis concealing the sportswear under her clothing and in her purse. That officer, who was holding his walkie-talkie type radio transmitter, followed her out of the store. When about 10 feet outside, she turned to see this officer directly approaching her, radio in hand. She then ran back into the store where she threw the sportswear under a rack displaying other clothing. after initially physically resisting, threatening, yelling, and thereby creating a disturbance, she was eventually apprehended by the officer and other officers who responded to his radio call. Yelling at the first officer who was attempting to calm her and direct her to the store offices, Ms. Ellis insisted, "You have nothing on me. I'm not going to jail." Guess what, folks? She went to jail because this is theft under 1467. The essential or specific intent element in the crime of a taking, theft, exists when the trier of fact finds that the circumstances indicate that the offender, here Miss Ellis, actively desired to permanently deprive the owner of the sportswear when she concealed it on her person and in her purse and departed the store. Basically, the fact that she changed her mind later, too bad the theft is already completed. Shoplifting is theft. Theft is a specific intent crime. The offender must intend to permanently deprive the owner of the item. Another crime that we need to learn about that's very similar to theft, 1469, illegal possession of stolen things, which is also in your statutory supplement. Illegal possession of stolen things is the intentional possessing, procuring, receiving, or concealing of anything of value which has been the subject of any robbery or theft under circumstances which indicate that the offender knew or had good reason to believe that the thing was the subject of one of these offenses. We had a case, State v. Sanders. What happened in Sanders? The defendant was found asleep in a stolen car with the motor running at the corner of Fern and Olive Street in New Orleans. The steering column was defeated, a door lock was broken, the trunk lock was broken, and a screwdriver was found between the front seats. The court in this case indicated that Ronald J. Sanders was charged by bill of information with possession of stolen property. Note that the crime used to be called possession of stolen property. The name is now illegal possession of stolen things. The elements of the crime of illegal possession of stolen things are: the property was stolen, the property was of value, the defendant knew or should have known the property was stolen, the defendant intentionally possessed, procured, received, or concealed the property. Now, how do we get these elements proven? Who do you think is called to testify at the trial? Well, you would call the owner of the car. You would call the owner to tell that, "I don't know this guy. My car was stolen." And when you look at the condition of the car, when you have the steering column broken, the individual's asleep, there's a screwdriver, those facts to me look like illegal possession of stolen things. The guy basically said he was just taking a little nap. He said, if you look at the case, that he was out drinking on October 10th, 1987 at a bar. And when he decided to go home at about 2:30, a man from the bar offered him a ride. They were riding on Laurel Line when the man stopped, went upstairs, and never came back. Sanders pulled the car over to the curb. He had spilled a drink on his shirt and took it off. The man who gave him a ride also gave him the blue jacket to put on. He said he was in the car from about 2:30 a.m. until 7 a.m. and the car was running the entire time. He denied ever seeing the screwdriver or noticing that the steering column had been broken. Sanders admitted 4 prior convictions, 3 for theft and 1 for burglary of a residence. Well, for some reason, I guess the defense attorney who defended this case decided that it was best for his client to testify. So when his client testifies, as you know, a person's prior convictions are admissible, so the jury gets to know about those. So the jury basically said, we have here a car thief. They couldn't prove that he stole it but they could prove that he illegally possessed it. So therefore, he was charged and convicted with, I guess at that time that was called possession of stolen property, now illegal possession of stolen things. This will be a tough one to defend, folks, because if you put him on the stand, they say he's a thief. If he's not on the stand, you basically have no choice. So it's a catch-22 situation. Again, the elements, you need to know these for the final. All right, that is the end of this lecture. I do hope that you enjoy the rest of your day.